Freedom of profession, occupation, trade or business, Articles 19(1)(g) and 19(6). Article 19(1)(g) guarantees that all citizens shall have the right to practice any profession or to carry on any occupation, trade or business. However, the right to carry on a profession, trade or business is not unqualified. It can be restricted and regulated by authority of law. Thus, the state can, under Clause 6 of Article 19, make any law. A. Imposing reasonable restriction on this right in the interest of public. B. Prescribing professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. C. Enabling the state to carry on any trade or business to the exclusion of citizens wholly or partially. In P.A. Inamdar vs. State of Maharashtra, AIR 2005, it has been held that the right to establish an educational institution, for charity or for profit, being an occupation is guaranteed under the Constitution to all citizens under Article 19(1)(g) and to minorities under Article 30. Education, even though is an occupation, but it cannot be equated with trade or business. In short, education is national wealth essential for the nation's progress and prosperity. Notwithstanding the fact that the right of a minority to establish and administer an educational institution would be protected by Article 19(1)(g), yet the founding fathers of the Constitution felt the need of enacting Article 30. The reason is obvious. Article 30 is intended to instill confidence in minorities against any encroachment by the executive or legislature. Article 19(1)(g) is subject to reasonable restrictions under Clause 6 of Article 19. Article 30 has been therefore enacted to give them additional protection. However, merely because Article 30(1) has been enacted, minority educational institutions do not become immune from the operation of regulatory measures because the right to administer does not include the right to maladminister. The real purpose sought to be achieved by Article 30 is to give minorities some additional protection. The right to carry on a business includes a right to close it at any time the owner likes. So, the state cannot compel a citizen to carry on business against his will. But as no right is absolute, the right to close a business is also not an absolute right. It can be restricted, regulated or controlled by law in the interest of public. The right to close down a business cannot be equated or placed at par as high as the right not to start and carry on business. If one does not start a business at all, then, under the circumstances, he cannot be compelled to start one. But if one has started or been carrying on a business, he has no absolute right to close it. He can be compelled not to close down his business in the interest of general public. In Excelsior vs. Union of India, AIR 1979, the petitioner Excelsior was a registered firm. It had a factory at Bombay where it manufactured garments for exports. Due to serious labor trouble, the factory was running into a recurring loss. The petitioners, finding it almost impossible to carry on business of the factory, served a notice on the state government for prior approval for its closure. The government refused approval in the public interest. The government refused approval under Sections 25 or 25R of the Industrial Disputes Act, 1947. Section 25O of the Industrial Disputes Act requires an employer to take permission from the government for closure of his industrial undertaking. The employer is required to give a 3 months notice to the government. The government could refuse the permission to close down the business if it is satisfied that the reasons given by the employer were not adequate and sufficient, or that such closure is prejudicial to the public interest. Section 25R provides punishment for violation of Section 25O. The Supreme Court held that Section 25O of the Act as a whole and Section 25R insofar as it relates to the awarding of punishment for violation of the provisions of Section 25O were unconstitutional and invalid for violation of Article 19, 1g of the Constitution. The court said that nobody has got a right to carry on the business if he cannot pay even minimum wages to the laborers. He must then close down his business. The refusal not to close down business, even if he cannot pay, is not a reasonable restriction in the public interest within the meaning of Article 19, 6 of the Constitution. In Fertilizer Corporation Kamgar Union vs. Union of India, AIR 1981, it has been held that Article 19, 1g does not guarantee the right to work in a particular post of one's own choice. The closure of an establishment in which a workman is employed does not by itself infringe the fundamental right to carry on an occupation under Article 19, 1g. If workers are retrenched in a factory, they can pursue any other occupation. In that case, the workers' union had challenged the validity of the sale of certain plants of the corporation, namely, the Sindri Fertilizer Factory, on the grounds, inter alia, that it would result in the retrenchment of 11,000 workers employed in the company, and thus the sale would deprive them of their right to carry on their occupation as industrial workers. Similarly, in K. Rajendra vs. State of Tamil Nadu, AIR 1982, the post of part-time village officers were abolished under the Tamil Nadu Abolition of Posts of Part-Time Village Officers Act, 1981. It was held that the Act was not violative of Article 19, 1g. In Khode Distilleries Limited vs. State of Karnataka, 1995, the Supreme Court has set rest the controversy arising out of conflicting decisions of the Supreme Court on the matter whether a citizen has fundamental right to trade or business in liquor. The Supreme Court has summarized the law relating to right to carry on trade or business in potable liquor. The court has held that the rights under Article 19, 1 are not absolute but qualified, and the state is authorized under clauses 2 to 6 of Article 19 to impose reasonable restrictions.